Taigi, sugrįžę tęsėme seminarą
Ladies and
duomenų
gentlemen, shall we
apsaugos tema.
continue with data
Visų čia
protection?
dalyvaujančių salėje
I
paprašysiu
would ask
naudoti
everyone in the
ausines
hall to
tam, kad
use
gerai
headphones so that
girdėtumėt
you
visus
can
pranešėjus.
be better
Taip
placed
pat
to hear the
priminsiu
speakers.
užpildyti
Please also note
seminaro
that you are
vertinimo
required
anketas ir
to fill in
palikti
the
salėje, o dalyvaujančių
questionnaires on the
nuotoliniu būdu
seminar and leave them in
paprašysiu
the hall.
atsiųsti
And I
anketas
will
į
ask those who
notarų
are taking part
notarų rūmų
remotely
elektroniniu
to
paštu
send the filled-in questionnaires
rūmai@notarai.lt.
to the at
Taigi,
notary.lt, to the email of the Notary
pagal
Chamber,
programą
so that we can
apie duomenų
assess
subjektų
the
teisės
data.
mums pranešimą skaitys
Under
Miglė
our
Petkevičienė.
agenda now we will hear
Lietuvos
from
duomenų
Miglė
apsaugos
Petkevičienė, a member of the
pareigūnų
board of Lithuanian
asociacijos
Association of
valdybos
Data
narė,
Protection Officers,
Eleks
partner at
advokatų
Alex Law
kontoros
Firm,
advokatė.
and she will speak about the right of
Dėkojame
the person
gerbiamai
concerned,
Miglei,
of the
kad ji
data subjects.
sutiko pasidalinti savo
Rights of the data
žiniomis ir
subjects.
kviečiame ją
We thank
pasisakyti,
Miglė Petkevičienė
jeigu
for
jau yra
being ready to
prisijungusi
share
prie mūsų.
her experience.
Girdit mane?
We invite her to join. Can you hear me? Hello, can you hear me?
Negirdžiu, kad kas nors sakytų, bet jeigu negirdėsit,
If you don't hear me well,
puiku,
please let me
girdit.
know. Okay, I can see you can
Sveiki,
hear me.
laba diena.
Welcome.
And
Good
now
morning.
I will switch to English, because I was asked to switch myself to English. And now I hear the voice of the translator, so I don't know how to do that, but hopefully our technical staff will somehow silence that for me. And I will start sharing the screen. I hope you can see it. Okay. And I saw that some of the speakers have had some issues with their internet, their technical problems. So I hope the internet gods will save you from that, and everything will be great. So I will start my presentation. I know that you have just recently came back from your
Miglė,
lunch
aš
break.
labai atsiprašau jūsų.
Just to make sure that
Jūs mane girdite?
I get back the attention. And
Miglė, can we ask you for attention?
I will try to start with a bit of funny quotes and funny examples, so that you all are on the same page with me and that you are present here and I get your attention. So thank you very much for inviting me to this event. I'm really happy to be here with you. So as I was introduced, I'm a board member of Data Protection Officers Association of Lithuania, and I'm
Gerbiama
also a
Miglė,
partner
ar
at
jūs
law
mane
firm
girdite?
Alex.
Turiu jums vieną
So
prašymą.
there's this urban myth about the dragon named General Data Protection Regulation. So the legend says that it is highly complex, it's very scary, it's over 90 pages long, it's 99 articles plus extra almost 200 recitals. It never sleeps, it is applied to all situations and all circumstances, and the companies and all the institutions and all the data controllers, including notaries, shall stop whatever they do and start doing only data protection related work. And whoever asks to provide information about them, you have to put your hands up, give everything you have, and offer a candy on top or something. And that the authorities are coming with their swords to collect the fines. And oh, the fines, they're really huge. And everybody shall run and hide from those fines right now. So stop making notes. Of course, I'm really exaggerating. Data protection is not about that. These are just a few misconceptions, or, as I say, myths related to GDPR. But it's not really what defines data protection and data processing. So is it really complex? Yes, it is really complex, but it doesn't mean that it is too hard to understand or apply. Is it really applicable in all situations and circumstances with no exceptions? Yes, it's really, really applicable in all situations, but it has to be applied. It's not really the highest law. It has to be applied in parallel together with all other applicable laws. Is it an absolute priority? Sure, it is really important. and I will talk about it in a moment. It was already discussed today, but I will also try to address this in my presentation. So, are the rights granted to data subjects according to GDPR absolute? Well, no, they're not. There are some exceptions, there are some exemptions, and many other aspects have to be taken into account while granting. We'll talk about it in a moment. And fines, yes, sure, they are really high. They're really scary. They're up to 4% of company's annual turnover, or 20 million. But they're there with an aim to deter from the data breaches and to make companies or data controllers, including notaries, respect data and its privacy. So it's really not what defines the GDPR. GDPR is actually about the balance. I'm here to talk to you about data subject rights. So you, the most respectful notaries of all people, are really the ones to know that the balance is the key. Where there are rights, there are also obligations. And the fact that a person claims that he has a certain right does not make you free of any legal obligations you may have according to the law. Anytime certain person claims that he has a certain right according to GDPR, please remember not the dragon a few slides before, but this picture. Calm your mind, any noise that may be around. Remember the sea, the stones, maybe the noise and sound of the music of the waves. And try to think that actually there is a balance, and remember this perfect balance when you speak about the data protection rights. So let's talk about this balance in your work, especially in these daily situations where you may be asked to grant certain rights as a client, your interested party, or some other person, and how to find this balance and where does it lay in data protection. This is what we are actually going to talk about today. I will try to somehow mute the interpretation sound because it's really making me distracted, but I don't know how to do that. So, yep, if somebody from the technical team could help me with that, how to switch this, that I don't hear that. But yeah, so actually, as I mentioned, and as it was mentioned also in the Data Protection Authority's presentation, is that GDPR is actually all about respecting data privacy rights. So when we have any kind of data subject request, we definitely have to protect the personal data. All the data subjects have the right to the protection of personal data. But actually, it's also about the right balance with the other rights. So it's not an absolute right. It has to be balanced against other fundamental rights. It's also said in the GDPR, it's said in the recital 3 of the GDPR. So maybe this dragon, this urban myth that I have been telling from the beginning isn't what it really seems. And my today aims is to show you that this dragon may be friendly, sometimes even funny and nice, but it is never a bad guy. We have to help him do his job. So let's go to the discussion of rights of data subjects, and we'll go one by one to these data subject rights that are there in the GDPR. So the following rights may be granted to data subjects according to the GDPR. We will now talk one by one about them with the examples of their application in work as notaries' daily work. So they're actually regulated in the GDPR itself in the articles 12 to 22. I will not provide all the exact formulations of these rights in my slides, because I feel that if you try to read what is written in the slides, then you might lose the focus on the things that we are discussing and my words that I'm saying. So if you need to go into details how it is really regulated, how it's written in the law itself, you can just simply open the GDPR itself and try to see how they are regulated in the articles 12 to 22 as I mentioned. The first right we are going to discuss is right to transparent processing and right to information. We already heard about the basic principles of the GDPR in today's presentations. One of the basic principles that are really, really important is the transparency. So what does transparency mean in this context? So GDPR says that a data controller, this means that a notary as any other data controller shall take appropriate measures to provide any information referred to in Article 13 and 14, which means that information that is processed by a data controller, it shall provide this information to a data subject in concise, transparent, intelligible, and easily accessible form using clear and plain language. So information should be provided in writing or by other means, including where appropriate by electronic means. So when requested by data subject, the information could be provided orally, provided that the identity of the data subject is proven by any means. So how can a notary ensure this principle and this right to the data subject? So first of all, most of you notaries have the websites where you provide information about your contact details and about your actions, etc. So you could definitely upload your privacy policy or your internal rules of data processing into that website that you have. So simple, really one-way solution, simply one-click solution that you will definitely provide information to your data subject how you process this data. You can also make it available in your waiting room, for example, put it on the board, making a hard copy on your journal table, and it would be definitely accessible to anybody who's there in your office trying to make any kind of notarial action. This means that you provide information in a transparent and really accessible form. You provide it to anybody who enters your office. What you also have to do in terms of transparent processing and the right to information is you definitely have to provide video surveillance notices to the ones that are entering your office in case you are performing video surveillance. I know that most of the notaries do have video surveillance means in your office. What you have to do is provide it by notices. And I saw that in your internal, the chambers, notarial chambers approved version of your data processing rules really has this exemplary notification regarding your surveillance. So if you want to use that form, you can definitely access it, and it's really available to you, and it would be really beneficial to have such notice on your entrance to the office or near the camera that is there in your office. So just make sure that it's visible, it's clear, it's written in a plain language, and it's really accessible to all entering your office. And surely the other means of how you can provide information transparently, openly to all the subjects is you can provide it verbally or in a written form when you're already processing and providing the specific notarial action. So you can provide a copy of your internal rules for them to acknowledge and to see how data processing is really working inside your office. So this is actually a very simple right, and it's really, really important that you provide this transparent information in simple, easily understandable words to all of your clients, customers, or any interested parties that enter your office. The second right we are going to discuss is the right to access information. So a data subject should have a right to access the personal data which you have been collecting concerning him or her, and to exercise this right easily at reasonable intervals in order to be aware of and verify the lawfulness of the processing. So every data subject should have the right to know and obtain the information, in particular with regard to purposes for which the personal data is processed, where possible, the period for which personal data is processed, the recipients for which personal data has been provided, also if there's some kind of a profiling, so the logic under which this data processing and profiling is taking place, consequences of such processing, etc. So there is a list of this information. I can go on with it, but you will definitely find it inside the GDPR. So it's the existence of right to request the information from the controller, also a right to lodge the complaint, the existence of automated decision making if there's any in your activities. So there is a list of information that a specific person can access from you that you have to provide in case the person asks to provide information to him or her. So this is theory. What does it mean in practice for the notaries? So in practice, for the notaries, it means that, for example, if a person comes and asks, give me all the information you have, including all the wills I mentioned in, all the my name mentioned in, etc. So could you do that? Would you do that? And can you do that according to the law? So the only thing that a notary can provide in such a case is information that does not contradict to the confidentiality of notarial acts. So we all perfectly know this concept of notarial secret, and we all perfectly know the Article 14 of the law on notaries, which says that the notarial confidentiality of notarial acts should be assured in any case. So notaries must ensure the confidentiality, and for example, certificates concerning notarial acts and documents shall only be issued to legal and natural persons on the instruction of whom the notarial action was performed or their legal representative. I'm perfectly aware of this regulation. So certificates concerning wills shall be issued only after the death of the testator. This doesn't mean that the person can come and ask, well, am I in the will of my grandma who's about to pass out or something like that? We cannot do that. We can only do that when the person is already entitled to receive the specific will. Also, you know the professional secrecy. You do not disclose the facts that are part of notarial secrets. And what is said in the practice is that notaries shall at least, well, this is the minimum, what we have to ensure is we can disclose that information about him or her is actually processed within the specific bureau or not. So this is all you can say. You cannot say where it's processed, how it's processed, who mentioned your name in which document. The only thing that it says in the practice is that we can say, yes, your name is processed, or no, I don't have any information about you. And also, this right means that sometimes when a person asks, we would have to provide a copy of the documents containing his or her personal data. So it actually is a very interesting law, because it really depends on the volume. For example, once a year, the law, the theory says that once a year a person should be entitled to receive a copy of his or her documents. But I understand and I know that in notarial practice there is this practice that we are providing duplicates for certain specific amount of remuneration, right? And in my opinion, this right to receive a copy of your documents, of your personal information, could not be used as a way around this receiving a duplicate of your document. For example, you lost a document, you're going to a notary office saying, well, give me a copy of everything you have about me, and then you will receive a duplicate of the information or the document that the notary has. If a person wants a certified document, a certified copy of his or her agreement or a will, etc., it has to be a certain amount that covers the exact and actual costs of issuing of such document. Because it's providing a duplicate is actually a notarial act, not ensuring that the protection rights are made available. And if a person asks for processing of copy of his or her documents more than once in a year, you as notaries may charge a reasonable amount of fee based on administrative costs. How really much it costs, definitely for copying costs, etc., administrative costs. they should be, if a person wants to enjoy this right many times a year. Sometimes there are some people who are really just trying to implement their rights, not because they need some kind of information, but because they just want to annoy you or make some more encumbrances for you. So in these cases, you definitely can charge some amount of reasonable fee that covers at least your copying or your administrative fees. And I see that in the chat we have some, in the chat we have saying that we shall a bit take it slow, because maybe the translators are having a hard time to translating it. So I will try to be more slow, taking from further. I hope it's clear up until this part. And if you have any questions, I really encourage you to stop and ask the questions or put them in the chat box if you have any kind of questions or maybe some points to discuss, maybe an open discussion among ourselves to make this whole thing clear. So going to the next right, which is right to object. Next slide, right to object. So the data subject shall have the right to object on grounds relating to his or her particular situation at any time to processing of personal data concerning him or her. So in such case, the controller shall no longer process personal data unless the controller demonstrates compelling legitimate grounds that this processing overrides the interests, rights, and freedoms of the data subject. So this is the theory, right? So we need to enjoy the right of data protection, which is like right to object. But what does it mean in practice, and specifically, what does it mean in notarial practice? It is said that a person can object to processing of his or her data in case the obligations overrides the person's rights and interests. So, for example, in case of a credit note in Lithuanian vexels, so that will be lost in translation, right? So in case of a credit note, a person may not say, I object, for example, to processing of my data, and please do not process my data as a debtor because I object to such processing. In any case, notary has to perform certain obligations that he's entitled to, and there is no way that a person can, cover himself with this right by trying to somehow, avoid his obligations according to the credit note. Or the other example in your practice would be a person says, he or she gives like cash, which is more than 15,000 euros. And the person says, please do not transfer my information to Financial Crime Investigation Bureau. But this is actually a part of your job. In such a case, a person can object all he or she wants. If you have an obligation according to the law, this is what you do as a notary. You cannot listen to a person who says, please do not follow the law. You just have to do it, and there is no way the person could avoid his or her obligations in such a case. So let's move on. The other right is the right to limitation of processing. So again, let's talk about theory and then let's talk about practice. So the theory says that the data subject shall have the right to obtain from the controller restriction of processing where any of the conditions applies. For example, when the accuracy of personal data is contested by the data subject for a period enabling the controller to verify the accuracy of personal data, or where processing is unlawful and the data subject opposes to such process, or when the controller no longer needs the personal data for the purposes of the processing. So in these cases, the restriction of processing should be granted. But in notarial practice, let's speak about practice. I believe that this is one of the least used rights, and it's probably used in really little number of cases. One example I could think of is the person, for example, is saying there is a mistake in the register. There's a mistake in some kind of record of state enterprise registers in the extract, and he takes actions towards rectifying these mistakes. And in the meantime, he or she says, please do not rely on this information because this information is being rectified. This is not accurate. This is not true, and provides relevant proof. So in such case, I believe it's really normal to restrict the processing, not to go on carry processing activities, and to restrict the processing for a limited period of time when we need, in the meantime, when we need the information to be rectified. And then when the information is already rectified, it's really accurately described and reflected in the registers, then we can continue the processing. There's also this right to rectification. This example is also related to the one we just discussed. So in theory, the data subjects shall have the right to obtain from the data controller without the undue delay the rectification of inaccurate personal data concerning him or her. Taking into account the purposes of processing, the data subject shall have the right to have incomplete personal data completed or inaccurate data corrected, rectified, etc. So in practice, in case a person comes to a notary with such a request, the notary can request for documents to prove such request, that this request is really lawful. And in such case, the notary shall also notify the data recipients, meaning the ones they have transferred the data to, if that is really possible. So the person shall also have the right to know to which person the data has been transferred and ask for rectification as well if the data has been transferred to other data controllers or other subjects. Moving on, the right to data portability. And again, firstly, the theory. So the data subject shall have the right to receive personal data concerning him or her, which he or she wants to provide to the other controller in a structured, commonly used, machine-readable way, so that he or she can take the information and give it to some other controller for further processing. So here's the theory. And in all the cases, as I've mentioned before, theory is one thing, and in practice, it may mean totally different things. So it's really highly complex. Actually, the idea when GDPR was being drafted, and at the beginning when GDPR came into force, the idea was of this right was, for example, I have a clinic which takes care of my health, right? So I have the whole medical record here. I have all the information at a specific clinic or at a specific doctor that takes care of my health. And then I want to switch to the other clinic. I want to go to the other doctor, but I want the new doctor, the new clinic, to know everything about my health, so that he or she would continue my processes of my healing, of my surveillance of my health conditions, etc. So what I can do is request for all my health history from that specific clinic to be transferred to the other clinic, and the processing of my personal data continues, so as my healing continues. Right? The same about, for example, banks. I know I have all my spending history at one bank that I have been a client to, and then I want to switch the bank. I want to move to a different account, and then I take all the history of my spending to the other bank, and he or she knows that, well, this is what my current income is, this is how I spend the money, and this is how my bank account looks like. In case of notaries, in case of notarial practice, I have a really hard time finding a good example when and how this right could be used. It is easier to say what you can do. So you can't give the physical file or archives to the other controllers or to the same data subject itself. But this is what you have to keep according to the laws, so it does not apply to archive files. Maybe one similar thing that you are definitely doing in your notarial practice, similar thing is, for example, when a person comes, he or she has like inheritance file right in your notarial office, and he or she wants this file to be taken by another notary to bring it to another city, which is more convenient to him or her, etc. Right? So maybe this is the closest example that I could think of is taking the inheritance file to the other notary. But even in this case, this does not mean that you take the whole file and bring it to the other notary, right? This means that the notary shall have just the copies of the documents sent, transferred, but it doesn't mean taking the whole file out of you and bringing it to the other notary, because you still have the rights and obligations to keep the information that this particular file has been at your office and that you have already been processing this information related to here. So maybe this could be a good example, or maybe not. This is not actually the specific data protection right that you have in this law, this inheritance file transferring to another notary, but this is probably the closest example I could think of. Maybe you have other better examples of practice, and I would really together. So, moving to the last right, right to be forgotten. Actually, it's quite a funny too. When GDPR came into force, a little bit of history, some bad guy said, okay, now I'm going to the police, the enforcement agencies, to all the courts and all the general prosecution offices, and I'm going to say to them, I'll forget. And actually, it's not the case, and it didn't happen, and it will never happen in any case. You cannot forget a person if we have other legal grounds to further protect his or her data. So this right to be forgotten, as I mentioned in the beginning, these rights are not absolute, and we have to take into account also other laws that surround this processing. So right to be forgotten is not an absolute one, and if we have other legal grounds for processing of such data, we cannot forget the person, and we have to do what's written in the laws. So the law, the theory says that data subject shall have the right to obtain the erasure of personal data concerning him or her without undue delay, and the controller shall have the obligation to erase data without undue delay where this data is no longer necessary in relation to specific purposes, also where the data subject withdraws consent on which the processing is based, or when data subject to such processing, or where the data has been unlawfully processed. So this means that we know that there is no legal ground, and the person asks, well, please forget about me because you don't have a right to process such data. In this case, such could be charged. But if you have a consent and a person says, like, forget me, then what we have to do is we have to check if we do not have other legal grounds for processing of such data. So let's remember this example that we already talked about, this credit notes, this vexelis in Lithuanian. And actually, there was this one court case that I managed to find. It was in a Lithuanian court practice. And there are no similar court practices that I could find in Lithuanian or in European case law. So this only one case. And I will briefly tell you about the facts of this case. So the situation was that a person applied to a notary and to the Lithuanian Chamber of Notaries for the removal of his personal data from the public register of these protested bills of non-payment. It was published publicly available. It was made publicly available in notarurumai.lt website, in the info registry, specifically designed for announcing the credit notes, the vexed information. Both the notary and the Chamber of Notaries refused to delete this information, and definitely the data subject went to the authority, to the State Data Protection Inspectorate, and asked to oblige the notary and the Chambers of Notaries to take out this note, to delete this information from the state register. And the inspectorate, the State Data Protection Inspectorate, said, well, this request was unlawful and we shall not grant it. But when taken to the court, actually the court said that there is no specific data retention period and no term how long this information must be kept in the public register. But even if national law does not provide for this, and if there is no clear term on which the data shall be processed, GDPR must be followed and data should be removed when legal basis for processing disappears. And in that case, the data was published in when the non-payment was still there, but the person subsequently paid the debt and no longer was in debt. Therefore, the court said it doesn't no longer require processing. Therefore, this information shall be taken out from the publicly available records. It's no longer relevant. The person is no longer in debt. So this was the court case. Even if we know that we have the right to upload this credit note to official registers, but the person already paid the debt, this means that processing is no longer required and this information should be taken away from the register. So these are all 7 rights. Yeah, I'm sorry for being a bit rush in the beginning. I was really willing to put my all in 1 hour, put the whole material in 1 hour. So hopefully we will make it, because the only thing that is left is how do we do it? So how the process of implementation of data subject rights look like. So usually the request of data subject should be written. So what does it mean? It means that if a person comes to your office and says, now I want everything that you have about me, now please, for example, forget me, or I want to enjoy any of the rights that I have just mentioned in the presentation, what we can do is to offer them to sign a form. You have this form approved also in the Notary Chambers model document, which is related to data protection or internal model rules of data protection in the notary offices. So there is this form. If a person doesn't bring some kind of request by himself or herself, we could give them this form and ask them to fill it in. So it should be provided to you by appropriate means. This means that it could be provided to you personally, or by post, or by email, or by courier. And appropriate form should be followed. So it should be written in local language, it should be signed by a person, and the request should be made clear. It means that the person should say what he or she really expects from you, which rights he wants to enjoy. So you have to be clear, you have to understand what the person really wants from you. It doesn't mean that if a person brings a request in a different form that it is approved by the chambers of notaries, it doesn't mean that you reject it and say, well, this is the form that you have to fill in. If a person brings a request that is readable, it's understandable, you can see what a person really wants, it's in Lithuanian language, it is signed, you have to accept it, and you cannot deny granting it just because the form is not the one that has been approved by the chambers of notaries. We have to do as a next step, when we evaluate if the form is really right, we have to identify the data subject. So in case the request is given to you personally, the person comes and gives you this request as a written form, You have to check, you have to ask to provide also the ID of the person, just to make sure that the person who is submitting is the right person and he has the right to get this information. If the request is submitted by post or by courier, we have to request to provide a copy of ID. If, for example, we see that this information is not provided, we cannot say, well, this is a formal ground to reject that. What we have to do is to request for additional identification data or documents. We just have to simply ask for submission of a copy of ID, or, for example, ask that a person that comes to your office and shows you the ID so that you could proceed with further examination of such requests. If the request is submitted by electronic means, it should be signed by electronic signature, which is qualified or otherwise qualifies as electronic signature. If we identify and we know what the person really wants, so what is left for us is to implement such requests. So this could be done directly to the person, or if the person wants to get this information via representative, for example, he or she asks, well, please provide this information to my attorney or to my successor, or whoever he wishes the right to be implemented to, then we can do it not directly to the person, but to his or her representative. And also, as I mentioned in my presentation before, we have to definitely deny it in case it contradicts to other laws or professional secrecy of and if we see that the person requests for more information than we can provide to him or her according to the laws, we have to deny this request and not provide the information that term in which we have to respond to this request is 1 month. There is a possibility to extend it up to 2 months, but there should be reasonable grounds for such extension. For example, if the information requested is really extensive, if the for implementation of 5 rights instead of simply access to information. So if we need to somehow collect more information, or if we need additional time, so this is when we extend it. But this extension is more of an exception, not a rule. So in any case, we have to try to provide this information in 1 month period of time. And as I mentioned previously, we have to provide this information free of charge. We do not have to charge for implementation of rights unless, as I mentioned before, unless a person requests for a duplicate of certain document or implementation of any additional notarial acts that have not been performed before. So in this case, we charge normally, but usually implementation of the rights have to be provided free of charge. So it seems simple in this theory, in these charts, but the ones who already received such a request know that it's really, really complex. It might be really difficult to implement such requests, because usually the person asks for a lot of details, like, for example, who have you been giving my information to? So this means we have to go back to the file and see what was there more in the file. We also would have to check if the person has the right to receive this information. So we have to check all the documents and see what the notarial act was about. So was the person attending himself or by representatives, etc., etc. So it's not that easy as it seems. So the ones who already received such requests probably know what I'm talking about. And you can definitely expect this whole month of drafting the response, because it could be complex. Definitely, if a person has one similar small thing, it might be less complicated. But usually, these requests take a lot of time and a lot of effort. We want to provide all the information according to the laws. Coming back to the introduction, I'm almost finishing my presentation. So shall we see GDPR as, and especially the rights of data subjects, as threats or aggregations? Or shall we see it as business as usual with the only aim of balancing the rights and obligations of you as data controllers and your customers and clients or any other data subject? So I hope I made my point clear today that there is nothing to be afraid of. And the only thing we have to do is we have to act according to the laws, just like we usually do, just like you, your notaries usually do. So to sum up, there is a number of rights we have to grant data subjects, namely a right to transparent data processing and right to information, right to access, right to object, right to limitation of processing, right to rectification, also right to data portability and right to be forgotten. So these are the main rights. But none of these rights, as I mentioned, are absolute. They have certain limitations, they have certain conditions. And when granting such rights, we have to take into account the existing regulation and notarial secrecy, in particular, confidentiality of notarial actions. Therefore, in any case, when considering the data subject request, please consider whether there is a legal ground for granting such right, and make sure you act in accordance with law applicable in notarial practice. So this is what I wanted to tell you today. I really appreciate your attention. Thank you very much. And I know that there is one small video also waiting for you at the end of my presentation. So I think that this is about time we switch to that video. And if you have any questions, I'm always willing to respond and to advise if there are some problems or if you have any issues in granting the rights to your data subject. So thank you very much for attention, and I hope that it is as easy for you as balancing those stones and rocks, and just try to stay in line with notarial regulations, and I think everything is going to be fine. You do not have to fear it. We just have to face it as a usual practice. And I think that it has been almost 4 years when GDPR is in force, and we are slowly getting there to the phase of acceptance that we know that we have to grant such rights, and we are not afraid of it anymore, and this is what I wish.
Dėkojame gerbiamai Miglei už jos iš tiesų išsamų pranešimą. Labai atsiprašome už iškilusius techninius nesklandumus ir kviečiu jūs padaryti trumpą pertraukėlę tarp pranešimų ir pasižiūrėti antrą Europos Sąjungos notariatų tarybos parengtą informacinį video reportažą apie asmens duomenų apsaugą.
Les personnes concernées, c'est-à-dire les personnes dont les données sont traitées, clients ou collaborateurs, disposent en vertu du RGPD de plusieurs droits qui sont susceptibles d'être exercés à l'égard du notaire. Parmi ces droits, nous pouvons citer le droit à un traitement transparent, le droit à l'information, le droit d'accès, le droit de rectification, le droit à l'oubli, le droit à la limitation du traitement, le droit à la portabilité des données et enfin le droit d'opposition.
Parmi ces droits, concentrons-nous sur le droit à un traitement transparent et le droit à l'information, ainsi que sur le droit d'accès des personnes concernées. Il s'agit des droits auxquels les notaires sont les plus susceptibles d'être confrontés. Les traitements réalisés dès l'ouverture d'un dossier sont somme toute légitimes dans le chef du notaire. Ce dernier est dans ce cadre tenu par une obligation d'information à l'égard des personnes concernées. En effet, le citoyen a droit à ce que l'étude traite ses données à caractère personnel de manière transparente et dispose en outre d'un droit à l'information. Ainsi, le notaire doit expliquer clairement au citoyen quelles sont les raisons pour lesquelles il est amené à récolter les données à caractère personnel le concernant. Quelles sont les bases légales applicables ou encore quels sont les destinataires des données.
Il est intéressant de savoir que cette obligation d'information s'applique en toutes circonstances et donc même si le traitement est autorisé par ou en vertu d'une loi. à tout le moins lorsque les données sont récoltées directement auprès de la personne concernée. Ainsi, lorsque ces données sont collectées directement auprès de la personne concernée, le notaire lui communique les modalités des traitements de données. Quelles sont les finalités poursuivies, les destinataires, la base de licéité, les durées de conservation, et ce, au plus tard, au moment de la collecte.
La méthode d'information est laissée au libre choix du notaire, pour autant que le langage utilisé soit clair et compréhensible et que l'information soit aisément accessible. Afin de remplir cette obligation, le notaire rédigera une politique de protection des données qu'il remettra à ses clients lors du premier rendez-vous, qu'il publiera sur son site internet ou encore qu'il rendra accessible dans sa salle d'attente, par exemple sous la forme d'une affiche. Il pourra également ajouter en lien vers cette politique dans sa signature électronique et celle de ses collaborateurs.
Le citoyen peut à tout moment obtenir la confirmation auprès de l'étude du fait que ces données à caractère personnel sont ou ne sont pas traitées. Notons que le droit d'accès est certainement un des droits les plus utilisés à ce jour par les personnes concernées à l'égard des notaires. Le notaire, à l'origine de la recherche, est alors tenu de communiquer à la personne concernée les informations suivantes. Les raisons du traitement de données, c'est le principe de finalité, les catégories de données à caractère personnel concernées, les destinataires, leur durée de conservation, le cas échéant, l'existence d'un droit de rectification ou d'effacement, et enfin, la possibilité d'introduire une plainte auprès de l'autorité de contrôle.
Si le notaire ne peut pas répondre à la demande du citoyen, par exemple parce que celui-ci est un bénéficiaire testamentaire qui se renseigne sur les recherches effectuées à son égard, il l'en informe et explique les raisons de son refus, en l'occurrence le secret professionnel. Le notaire doit au moins mentionner le fait que le citoyen est concerné par un des dossiers dont il est chargé.
Taigi, pereiname prie kito mūsų pranešėjo, profesoriaus Dariaus Štytilio. Jis mus supažindins su bendrojo duomenų apsaugos reglamento nuostatų taikymų praktikoje ir kibernetinio saugumo temomis. Pranešėjas pirmojoje dalyje pristatys asmens duomenų apsaugos praktikoje ir kibernetinio saugumo teoriją,
GDPR in practice and cybersecurity, and his next theme he will invite you to engage in practical tasks. As far as I know, he is already with us online.
Can you see my screen?
Jūsų skaidres matome.
Do you hear me well?
Girdime, viskas puiku.
Okay, thank you.
Yes, we can.
We can start with the GDPR in practice and then personal data security and cyber security. Let's start from GDPR compliance. What is important? Just a minute. What is important for GDPR compliance, including the security side? Yes, GDPR documentation is necessary, but documents alone are not enough. In addition, provisions of GDPR documents are often out of practice and ineffective. This is called formal compliance. Also very important is organizational culture that starts with the view of the management, of organization management. A lot of depends on the tone set by the management and the example shown. So in other words, when we have notary office, so a lot of depends from the notaries itself. Understanding the security threats of the organization, its individual members, also very important. Thus, the organization needs to conduct personal data security training, during which should provide many examples and explanations, such as what phishing is and how it occurs, how to recognize it, and so on. And also, the third one, how to establish appropriate procedures. So, procedures and processes that are in practice are very important, including the procedure for reporting, assessing, and communicating personal data breaches. And only the sum of these elements can ensure real GDPR compliance in practice. Not only GDPR documents, but also, as I said, culture of the organization, processes and procedures that are in place. And now, accountability principle. The Article 5 of GDPR defines 7 principles relating to processing of personal data, which are from the backbone of GDPR and the data protection law in general. And all principles are important, but in practice, there are often questions about implementation of accountability principle. And a few words about accountability principle. It is one of the main principles in data protection law, and it makes data controller, also data processor, responsible for complying with the legislation, with the data protection requirements, and says that data controller must demonstrate compliance. Requirements also, accountability principle requires both data controllers and processors to actively and continuously implement measures to promote and safeguard data protection in daily life activities. And measures should be appropriate to the risks. And accountability enables you to minimize the risks of what you do with personal data by putting in place appropriate and effective policies, procedures, and measures. These must be proportionate to the risks, which can vary depending on the amount of data being processed, its sensitivity, technology use. For example, if you use mobile devices to access personal data, this should be evaluated in terms of risk assessment. For example, when considering an electronic system in Notary, we need to think about secure connection to such system, to personal data. Accordingly, we need to assess the risks to the data subject's rights and the level of secure access required. And controllers must be able to demonstrate compliance not only with data subjects, but also general public and, of course, to supervisory authority at any time. Processors must also comply, but their accountability obligations are a little bit different. For example, they have obligation to keep records of processing operations, to appoint DPO, etc. But data processors do not have the same level of GDPR compliance responsibilities, because main compliance responsibilities lie on data controllers. And notaries as data controllers should know this principle. About practical problem, data controllers usually do not provide sufficient information or evidence in response to inquiries from the supervisory authority, which could be considered as a breach of accountability principle. So, very important when data controllers receive any request from supervisory authority to answer the questions taking into account accountability principle, which means, as we already talked, that data controller should demonstrate compliance. For example, if the controller is asked to provide information on legal basis for the processing of personal data, and this basis is, let's say, legitimate interest. Let's say, an example, Lithuanian supervisory authority expects a balance that's to be provided to the authority. Otherwise, a breach of the accountability principle could be established. So it's very important to respond to any inquiries of supervisory authority, providing as much information as we can. And here we have self-questionnaire about accountability. From this list, we can see that key measures need to be taken by data controller. And I will try to quote this list. For example, we take responsibility for complying with GDPR at the highest management level and so our organization. So what does it mean? So, all organization should be involved in complying with GDPR principles and other legal norms. We keep evidence of the steps we take to comply with GDPR. For example, if we conduct data protection, some seminars or other activities, so we should we should keep evidence about this activity. We put in place appropriate technical and organizational measures, such, for example, adopting and implementing data protection policies, taking data protection design and default approach. What does it mean? So if you have any, for example, if the notary system as such has a new project, for example, e-notary, so data protection by design and by default principle should be taken into account. For example, we should think about data protection from the very beginning of the process of the project and through the whole implementation of the system. Putting written contracts in place with data processors. For example, if the notary has any data processors, for example, any firm that organizes, for example, financing issues, so there should be written contracts with that firm. Maintaining documentation of our processing activity, implementing appropriate security measures. We will speak about security measures a little bit later. Recording where necessary, reporting personal data breach, carrying out data protection impact assessment. We will talk as well about data protection impact assessment. Appointing data protection officer, and etc., etc. So there are a lot of measures that should be taken by data controller. And of course, the last but not least, we review and update our accountability measures and at appropriate intervals. So what does it mean? So when we have, for example, new documents, they should be reviewed after, for example, 1 or 2 years. So let's have several examples. The first examples about accountability principle. The first example is about PricewaterhouseCoopers company. This example, of course, is related with non-compliance with accountability principle. The Greek Data Protection Authority imposed a fine of 150,000 euros on Pricewaterhouse Greece company in 2019. And the employees of this company were forced to sign a statement of acceptance of terms of personal data, and consent was not freely given. The fine is for violating the principle of accountability under the GDPR Article 5 for not being able to provide internal documentation of its choice of legal basis. Why I do not provide examples about notaries' activities and fines? Because in Europe we have, for example, page enforcementtracker.com, and I tried to search notary, for example, keyword notary, but there were no results. So we can discuss only about examples from other areas. And the second example is related to the Lithuanian fintech company. The Lithuanian DPA imposed an administrative fines in 2019 in the amount of 61,050 euros, and on joint stock company, Mr. Tango, a payment service provider, for, among others, the breach of Article 5 of the GDPR. And it was determined that the company processed more personal data than was necessary for affecting the payment. For example, a number of issued payment cards, topics of submission, and etc. The DPA considered that the company breached the principle of data minimization, the first one. Furthermore, it was determined that the company stored the data longer than it had established and indicated as necessary by itself. For example, 216 days instead of 10 minutes. Let's imagine data was being stored 216 days instead of 10 minutes, only 10 minutes. Therefore, it was considered as breach of principle of storage limitation. And finally, the company also failed to provide sufficient evidence as regards its compliance with the data protection principles during the investigations. So therefore, breaching the principle of accountability. So the company did not cooperate with the Lithuanian Data Protection Authority. Thus, the failure to provide information to supervisory authority or insufficient information may be considered as breach of the accountability principle. And the third example, the third one, it's a German example. German authority issued in 2021 a fine of 300,000 euros on the soccer club Stuttgart for neglectful breach of the accountability principle under Article 5 of GDPR. The club just transferred several tens of thousands of personal data of club members to an external service provider, and the club failed to provide a contractual basis for its cooperation with the service provider. And I think that this service provider was from China. So the authority decided that there was a violation of the accountability obligation according to Article 5 of GDPR. And this was based on the fact that due to insufficient documentation of the contractual relationship with the external service provider. Of course, we have a lot of examples from all the European countries, but let's say we can talk about several of them. And in this slide, we can see that the principle of accountability is often violated together with other principles of the GDPR. Now, there are only 4 examples. The newest examples for 2021, end of 21, year 21. For example, Italy, it was fined for non-traceability of the calling numbers. It was related with direct marketing, and the data controller was not able to provide to whom they called and what was the number of calls. So non-traceability of the calling numbers, and they also did not provide information who is calling. So this was as a breach, treated as a breach of several principles, but of including accountability principle. Another example is from Poland. We see Warsaw University of Technology. The university was not able to demonstrate compliance regarding security measures. So it's very important in practice, and we will talk a little bit later, not only have security measures implemented, but to demonstrate implementation of those security measures. This is an example from Romania. This issue is related, for example, a complaint made by data subject claiming the receipt from the telecom operator of some invoices and notification messages regarding related with another person, a subscriber of the same company. And operator has incorrectly collected and processed certain inaccurate personal data, which was also led to the illegal disclosure of personal data to another individual, and which is a violation of the principles of personal data protection, including principle of accountability. And of course, we have a lot of similar examples when accountability is only one of the principles that were breached in the case of several cases. The next slide. So we can move to the records of processing activity. Records, it's an obligation coming from Article 30 of GDPR, and we see that record is a document with inventory and analysis of purposes, which must reflect some information among other about the actors involved, about categories of data processed, about purposes of data processing, who has access, what are the recipients of data, for how long the personal data are retaining. Also about technical and organizational security measures. And the records of processing activities, it's an internal document required by the regulation and is mostly commonly used to demonstrate compliance to the data protection supervisory authority. And there are records of processing activities must be kept both by data controllers and data processors. We can see that the content of the records of data controller and the data processor is different. If the data controller has to fill in more information because he's responsible for processing of personal data, the controller also has to show more on who's and the processor on the next slide will be must show on whose behalf he is processing personal data. So here we see requirements for data controllers records, and in the next slides we can see requirements for data processor records. For example, on whom behalf we can process data, what type of data we process, what security measures we implement, etc., etc. And usually, requirements to have data processing records is also indicated in a written contract between data controller and data processor. In this slide, we have an example that, for example, entries can be made simply in Excel form, entries to records of processing activity. But the records can also be filled using automatic tools, special programs. And here we have some example of such programs or applications. Some of them we must pay for some of them. So there are also perform other functions, for example, such as data inventory function or function related with privacy impact assessment. But one of the functions is exactly data processing records. And in practice, the records may be completed by the data protection officer or by other responsible person for such function. Also, from the practical point of view, aside from being an obligation settled by Article 30 of GDPR, the record is an internal control tool, and as I mentioned above, and a way to demonstrate compliance with GDPR. It always it allows you to document your data processing and to know what questions you must ask yourself before and while processing data. So it's a very good tool to control and to think about data processing operations and personal data you are processing. For example, do I really need certain data for this specific purpose, for this specific processing? Is it relevant to retain all of this data for so long? Are the data sufficiently protected, and etc. And creating and updating the records is very important function. This essential step will allow you to delineate an action plan of your processing complying with data protection rules. And here we have data protection impact assessment. Data protection impact assessment is some systematic method for assessing and documenting relevant data processing activity in order to answer questions regarding risks to data subjects. So the main issue with data protection impact assessment is that this is like a risk assessment, just risk assessment. And GDPR, as we see in the slide, is a process to help you identify and, of course, not only identify, but to minimize the data protection risks of a project or processing operation. So the task is not only to identify the risk, but to have measures that mitigate those risks. And GDPR mandates that the data controller conduct data protection impact assessment in certain circumstances. So it's an obligation for data controllers, not for data processors. But data processors, if they activities related with appropriate data processing tasks. So they should help data controllers to conduct a data protection impact assessment. Also, you must do a data protection impact processing protection impact assessment for processing that is likely to result a high risk to individuals. So the criteria is a high risk to individuals. And the question is how to know where we have or where we will have a high risk to individuals. The answers will be in next slides. Thus the data protection impact assessment does not have to be carried out on a case-by-case basis, but only in cases where processing of personal data poses a significant risk to data subjects. And here we have an example of self-monitoring questionnaire. The questionnaire helps to assess the risks of the data subjects of a project, for example, and helps to decide where an impact assessment is required. For this purpose, appropriate criteria are used, and they are presented in my next slide. So we can see the criteria, 9 criteria, the old directives, data protection directives, working party of Article 29 has named 9 criteria for processing operations that might lead to an assessment if at least, so the main rule is if at least 2 criteria are met, so data protection impact assessment should be conducted. Sometimes 1 criteria is enough, for example, processing of sensitive or highly personal data. Sometimes it's enough only have 1 criteria. But basically, the basic rule is when we evaluate a new project and analyzing those criteria, it is enough that 2 criteria are met, and in this case, obligation arises to conduct data protection impact assessment. And Article 35 of the GDPR provides that each supervisory authority must establish and publish a list of the categories of processing operations which are subject to data protection impact assessment requirements. For example, France data protection body has published a list of categories for data processing operations that require data protection impact assessment. And here we have types of processing operations, and on the right we have criteria, and we see that at least 2 criteria are met, sometimes 3 criteria are met. So this is list also called blacklist of processing operations that require data processing impact assessment. And the same situation is in other countries. For example, Lithuanian Data Protection Authority also approved a similar list of data protection operations that require data processing impact assessment. And the main rules is as follows. The fact that personal data protection operation is not included in the mandatory list does not mean that an impact assessment is not required at all, because it may be needed to analyze those criteria, those 9 criteria, and maybe some of the criteria are overlapping. So sometimes data controllers decided to carry out impact assessment based not only on the obligatory list, but on those 9 criteria. But in practice, there are also such examples when data controllers decide to carry out impact assessment on his own initiative in order to identify and manage risks of the project. For example, yes, we can analyze the obligatory list, and there is no such operation in the list, and there are none of criteria met, but we want to analyze risks of a project. So we decide to carry out impact assessment in our initiative. So this is also possible. And here we have steps of data protection impact assessment or cycle. A data protection impact assessment should begin early in the first step of the project, before, for example, you start your processing activities, and run alongside the planning and development process. And it should include these steps. We can start with identifying needs of data processing impact assessment. Later, we describe the processing. It's a data inventory, in other words. Later, we consider consultation, assess necessity of proportionality, identify and assess risks, identify measures to mitigate risks. We record, of course, outcomes and integrate outcomes in a plan, and of course keep under review our data protection impact assessment. So, of course, data protection impact assessment is also one of the practical implementation of principle of accountability. And it's a very good tool for the controller itself to identify and manage data protection risks, risks to data subject rights. And now we can see that there are some templates. This template is coming from France. Of course, the Lithuanian Data Protection Authority also adopted some recommendation about privacy impactment, how to perform privacy impactment assessment. And the most common problems in practice are as follows. When data controller does not realize then that evaluation is required and no evaluation is being carried out. Yes, there are some such cases where data controller just do not know that he has obligation to perform data protection impact assessment. Also, another problem is maybe related with incorrect indication of risks. I saw a lot of, quite a lot data protection impact assessments in practice with non-correct indication of risks. The risks were of general nature and not related with appropriate projects. And our Lithuanian Data Protection Authority also says that one of the risks when carrying data protection impact assessment not to indicate appropriate risks in the assessment. And another problem is no residual risks indicated. So when we have the initial risk, we should think about what measures should mitigate this risk. And later on, we should evaluate what is the residual risks. And the last but not the least practical problem when the assessment is carried out by the data protection officer, DPO, because DPO only has to, according to the GDPR, only has to advise or consult in the process of data protection impact assessment. But we have in Lithuania, especially, a lot of cases when a DPO directly conducts data protection impact assessment. This is a breach of GDPR also. And here we have, today I'm providing a lot of examples from France. And this is another example. And here we have application created, initiated by France Data Protection Authority. This application is automatic tool which helps you to conduct data protection impact assessment. And this tool is for free, and you can download at any time this automatic tool and just to try to conduct data protection impact assessment. Some of the specialists, they just learn from this tool how data protection impact assessment should be conducted. And let's talk a little bit about data protection officer position. So the primary role of the data protection officer, of course, is to ensure that organization processes and the personal data of its staff, customers, providers, or any other individuals is in compliance with the applicable data protection rules. And here we see the main tasks of DPO defined in Article 39 of GDPR. And we can see to inform, to advise employees about obligations coming from GDPR, to monitor compliance with GDPR, to raise awareness of data protection issues, so training activity, staff training activity, conducting internal audits, also to advise and to monitor data protection impact assessment, as we talked already, not to conduct, but only to advise and monitor, to cooperate with supervisory institutions, and of course to be first point of contact for the supervisory authority and for the data subjects. And data subject could be, as you already know, internal or external ones. And position of DPO, it's like a self-questionnaire that helps you to evaluate if everything is okay with the position of DPO. For example, our DPO reports directly to our highest level of management and is given the required independence to perform their tasks. We involve DPO in all issues relating to the data protection of personal data. Our DPO is sufficiently well resourced to be able to perform the tasks and functions. And of course, to ensure that any other task or duties we assign to our DPO do not result in a conflict of interest with their role as a DPO. For example, IT specialists who implement security measures could not be a DPO because he will control itself how he implements security measures. Very important, what is very important in the daily life of the DPO's activity, proactivity, initiative, participation in the meetings regarding personal data protection, regarding any projects related with data processing. So involvement in the projects from the early stages, involvement in training. Of course, annual reports should be provided. Understanding not what is very, very important, and understanding not only legal issues, but also IT security issues. So the DPO is integral part of the organization making her ideally placed to ensure compliance. This is not a formal position. Much depends on the DPO, but the compliance depends not only on the DPO, but also on each employee. And there is a mistake when appointing a DPO and expecting it alone will solve all the problems related with GDPR compliance. So this is a mistake, and DPO must help, consult, initiate, and etc. But compliance must be ensured through the whole organization, and every employee must contribute to the compliance. And the officer, data protection officers, should be more like a consultant, advisor. But as I said, it's a mistake to appoint DPO and expect that DPO will solve all the problems. Okay, so here we have, today we will have several tasks. One task we will have now, and 3 tasks we will have after our part about data security, about personal data security. The first task is for warming up, let's say. The task, now let's start, for example, you can see a statement and several possible answers. And one or more answers may be correct. So one or more answers may be correct. This particular task, you need to provide the right answer from each table. I don't know how many tables you have today. I think 7. And this task should take up to 5 minutes. And if you take less time, we can discuss the answer sooner. So please read the task and please indicate the correct answer or answers. So up to 5 minutes, and I will wait the answers from each of the table. And we can start from now, up to 5 minutes, and I will wait for the answer. So which answer is correct and why? I see. I hope you see the text clearly.
Jeigu jūs man leisite, gerbėmieji mūsų klausytojai seminaro, aš paprašyčiau mūsų 5-ojo stalo pateikti savo siūlomus atsakymų variantus. Paprašysiu mūsų gerbiamo profesoriaus šiek tiek suteikti mums daugiau laiko dėl tiesiog techninių tokių sprendimų ir vertimo pateikimo mūsų gerbiamiems svečiams. Dėkoju labai, profesoriau.
Thank you very much, Professor.
So the answer from table 5 is the first one, yes? If I understand correctly.
Profesoriau, atsiprašau jūsų, kadangi mes susidūrėme su šiokiais tokiais techniniais vertimo nesklandumais, galbūt jūs pats galėtumėte išversti mums uždavinį šį taip pat ir į lietuvių kalbą. Ar galėčiau jūsų to paprašyti?
Ką tik tas buvo padaryta, bet aš galiu pakartoti. Reikėtų, taip?
Jeigu tai buvo atlikta ir visiems salėje yra aišku, tai viskas tada gerai.
You don't need to.
If I need to once again to translate to Lithuanian language, so please indicate. So this is a little tricky task, so please read carefully all the answers. And later I will explain why appropriate answer is correct and why other answers are not.
Aš matau, kad kolegos penktojo stalo tarėsi, bet noriu paklausti, ar jūs jau turite preliminarų atsakymą, ar jums dar reikėtų kelių minučių pasitarti?
And of course, not only please say which answer is correct, but why this answer is correct.
So, do you hear me?
Yes.
Do you hear me?
Yes, I hear.
Okay.
I hear you.
So we discussed the question, and we are not very sure, but we think that it might be the answer number 2 and number 4.
Yeah. So the option is number 2 and number 4. Yes. Which table it was? Could you please?
Jeigu aš gerai matau, tai yra penktasis stalas.
Thank you. Are there any other opinions about the correct answers from other tables?
Kadangi turime pakankamai ribotą laiką, prašysime gal jūsų profesoriau tada pakomentuoti atsakymų variantus.
Okay, so of course I see that our time is limited today. So the correct answer is the first answer. The controller and shall be responsible for and be able to demonstrate compliance with principles relating to data processing of personal data. Why this answer is correct? If you remember, one of the slides on accountability mentioned that 2 things were important to be responsible for compliance and the ability to demonstrate compliance. So responsible and ability to demonstrate compliance. But the first answer is correct because it mentions both of these elements. For what reasons other answers are not correct? For example, the second and third and fourth are inappropriate due to the fact that the controller and the processors, as already was mentioned, do not have equivalent accountability requirements. So the scope of accountability requirements for the controller and the processor varies. Therefore, the only correct answer is the first answer. So, okay, can we move further with personal data security? Until the break, we still have about 12 minutes. And after that, we will continue. So personal data security, it's a very important part of GDPR related personal data security. And we can start with the fact that the basis of both personal data security and cyber security is so-called CIA triad. What does it mean? This triad consists of three parts: availability, integrity, and confidentiality. Here we have some explanations. What does confidentiality, availability, integrity mean? In practice, all the measures implemented to ensure confidentiality are designed to prevent the information, personal data from being accessed by unauthorized individuals, by unauthorized entities or processes, while ensuring that authorized individual entities have access to it. An example would be sending personal data outside to the wrong email address. So in case of sending personal data, email with personal data to wrong email address, it already is treated like personal data security breach according to GDPR. The second one, integrity, implies maintaining the consistency, accuracy, and trustworthiness of information, personal data over the entire life cycle. So data must not be changed in transit, and measures must be undertaken to ensure that data cannot be altered by unauthorized individuals, entities, or processes. From practical point of view, this means that data cannot be modified in an unauthorized way or in undetected manner. And availability, this means that the system, for example, information system used to store or process information, personal data, as well information communication channels are all functioning correctly. An example could be the DOS attacks that result in a loss of access to personal data. DDoS, I can repeat, DDoS attacks that result in a loss of access to personal data. In the area of information security, there are several standards and frameworks providing for different types of controls and following the CIA triad. So the most known and widely employed is standard ISO number 27000 family. So usually data controllers or data processors in practice implement one of the standards or several standards from this family, number 27000. And we will see later a breach of at least one of these elements is considered or could be considered as a breach of personal data security. So, and of course, several elements can be breached during the same time, during the same, for example, attack or etc. So this is the base of personal data security as well as cybersecurity. And part of Article 5 of GDPR, Part F, says that personal data should be processed in a manner that ensures appropriate security of personal data, including protection from unauthorized or unlawful processing and against accident and loss, destruction or damage using appropriate technical or organizational measures. As we can see, the CIA triad is integrated in this principle. And security measures should be appropriate, not maximum in every case, but should be appropriate to risks that are related with processing of personal data. And in GDPR, we have one main article, article number 32, security of processing, And it should be noted that the regulation does not lay down specific security measures, but sets out a rather criteria. We see that security measures should be based on a number of criteria, for example, nature of personal data, scope, context, purposes of processing it, etc. And one of which is so-called risk-based approach. So criteria regarding risk. And the list of security measures we can see in this article is not exhaustive. It's like example, what security measures could be implemented. For example, pseudonymization or encryption of personal data, or regular testing, assessing and evaluating of effectiveness of technical and organizational measures. And it's very important that regulation does not allow to national states to implement appropriate legal acts regulating security of personal data. Therefore, recommendations are often issued in national states, which set out detailed security measures. This is the case also in Lithuania. In Lithuania, we have separate recommendations regarding IT security measures and risk assessment. And the main issue is so-called risk-based approach. As I already told, technical and organizational measures must be adequate to the risk, and processing of personal data must assess nature, volume, context, purposes, and of course, close relations with data protection impact assessment. In this case, risks are also assessed, but usually in the context of specific project or information system, and risks are assessed more broadly, not just only security risks. So risk assessment in case of data protection impact assessment is much broader than only security risk assessment. Here we have traditional risk assessment methodology coming from ISO standards, also ENISA, European Network and Information Security Agency documents. And the methodology is very simple. We should identify, of course, threats and threat occurrence probability. Then we should identify impact, and at the end we receive risk level. For example, if we have threat occurrence probability at low level and impact high or very high, at the end we receive a high level of risk. So this methodology is using in every case when evaluating security risks or evaluating risk related with some project while doing data protection impact assessment. This picture maybe will be more clear. We have 4 options in this picture, and in the first case, it is likely that the person will jump over the hollow, but even if he does not jump, the impact will be small, such as getting his feet wet, for example. It means that high probability and low impact. In the second case, we see low in both cases. In the third one means that also the time chances of not jumping are low, but if this person don't jump over the hollow, he will probably have major problems. There can be a serious, for example, health risks It means low probability and high impact. And in the last case, we have high probability and high impact. The same is with the risk to privacy and personal data processing. And the methodologies for risk assessment and security measures in particularly are based on this principle. Okay, and I can see that we have 4 p.m. On Lithuanian time. And I think according to agenda, it should be a break for half an hour, if I'm correct.
Taip, dėkoju Jums tada, profesoriau, už Jūsų pirmąją pranešimo dalį ir skelbiame kavos pertrauką, o po jos vėl susitiksime.
Okay, we will meet in half an hour.